This week on Legal Talk with Hahn and Hahn Attorneys, we are discussing insubordination. In fact, my employees constantly defy my authority as the employer. What should I do? So let's talk about insubordination in the workplace. First of all, welcoming Olebogeng, Mangena from Hahn and Hahn Attorneys. How's it going, Olebogeng?
Oh, this is good, man. Thanks. How are you?
Good, thank you. Thank you, as always, for joining us here on Legal Talk. Olebogeng, first of all, what is insubordination?
So, insubordination, with specific reference to the workplace, it refers to an employee's intentional refusal to obey an employer's lawful and reasonable orders. And also, the Collins Concise Dictionary provides a broader meaning to an behavior that is insubordinate, to say that it's a behavior that is not submissive to authority. It is disobedient and rebellious. It is the refusal of an employee to, maybe if I could say, bow to the authority exercised reasonably by the employee's superior. So it does not really limit the authority to that of the employer, but also superiors or people in managerial positions.
Can you tell us about the characteristics of an insubordinate employee?
So it can take place or form by way of actions, words, or as well as attitude that displays the lack of respect and compliance. They include, but not limited to, the resistance or defiance of authority, disobedience, refusal and failure to obey reasonable and lawful instructions, insolence, rudeness, and rebellious behavior.
What avenues can an employer now explore to correct the behavior of this employee?
So, given how the Labor Relations Act protects employees, the employer can start by having a coaching and problem-solving dialogue with the employee, and if that measure does not lead to any success, then employer can issue a verbal warning, which will be followed by a written one, and maybe a suspension. But the employee is not entitled to just terminate the employment relationship. However, it must be noted that insubordination must not be ignored, as it would result in more insubordinate behavior. Even if it's mild, letting it go would set an example that the superior's instructions are just suggestions and not rules. This does not mean that the managers must micromanage, but when they give an explicit instruction, an employee does not follow them, it must be pointed out.
Olebogeng, are the avenues that you just mentioned absolute?
In my opinion, they are not, because, for example, for suspension to take place, the employer must be able to prove that the conduct of the employees justifies such suspension or dismissal, and must also prove that the employee deliberately refused to obey a lawful and reasonable instruction by the employer. So the steps of proving that would involve the employer or supervisor issuing an instruction, and secondly, the employee receiving that instruction, and lastly, the employee refusing to execute that instruction. So the employer must prove those elements.
Right. And then what does not constitute an insubordinate behavior?
Not every conflict or misunderstanding between an employer and employee would result to an insubordinate behavior. If an employee, for example, misunderstands the instruction or does not receive the direction, or is otherwise unable to complete the task because of misunderstanding or an obstruction, that would not constitute insubordination.
And what constitutes an instruction from an employer lawful and reasonable?
In my view, a lawful and reasonable instruction is one that the employee is capable of carrying out, and it involves a task that is not substantially beneath the employee, and it does not infringe the rules of the employer or the laws of the country, and also it must involve the task that really needs to be done. If I can give an example. If the employer tells the human resource manager, who is on a 4-day contract, to come in on weekend to repair, let's say, a faulty elevator, such employee might be entitled to refuse the instruction because the instruction is completely outside the spheres of HR duties, and the HR manager is incapable of performing such acts, and it is assigned for the time that is not normally worked. However, if the human resource manager is being told to conduct a recruitment interviews because the HR officer is, for example, in hospital, in most cases that instruction would be legal and reasonable.
And then our final question for today. What is the difference between disrespect and insubordination in the workplace?
Insubordination would normally apply upwards and can only be perpetrated by a junior towards a senior. And whereas disrespect, on the other hand, can apply towards upwards and downwards. For example, if it would be disrespectful for a manager to shout at the employee or tell him or her to get out of the office. And therefore, disrespect is not necessarily linked to a person's position of authority, but is linked to one's human dignity.
All right, and that's insubordination in a nutshell. Olebogeng Mangena, Senior Candidate Attorney at Hahn Attorneys. Thank you so much for your time, and wishing you a wonderful festive season.
Thank you, man. It's a pleasure, and have a great one yourself.
Thank you.
Are you or your business in trouble and struggling to find a solution? Call Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn Attorneys, Wednesday mornings at 10 on eRadio.